Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. On the 14th of November, the UK government and the EU agreed the draft Brexit agreement. It's a 585-page document that we have summarised here in a couple of paragraphs. If a draft agreement is approved, the UK will technically leave the EU on the 29th of March 2019. There will be a transitional arrangement until December 2020 where things will essentially stay as they are. The UK will still be in the single market, be subject to EU laws, and there will still be free movement of people. If a deal is still not reached by December 2020, Northern Ireland will stay aligned to some rules of the EU single market, and the rest of the UK will temporarily maintain a single customs territory with the EU. As the days go by, the prospect of a draft being approved seems more and more remote, so a crystal ball is still needed. We have previously reported on the new corporate reporting obligations that will be implemented on the 1st of January 2019. These include a requirement for large companies to explain how the directors have complied with their duty to promote the success of the company. The government has published an updated Q&A document on the reporting obligations, and this is available on the government website. We have recently reported on a spate of decisions concerning legal privilege, and here is another one. Legal advice privilege generally protects documents passing between a lawyer and the client for the purpose of legal advice, but the court in Glaxo Wellcome v Sandoz decided that legal privilege would not protect documents passing between an in-house lawyer and internal clients if the in-house lawyer is merely collating those documents to send on to external lawyers for advice. Without a signed contract, it's often difficult to assess when and if a contract has ever been formed. Ultimately, the court will assess whether and when the parties' communications by words or conduct show that they intended to be bound and had agreed the terms that they regarded as essential. A recent case has helped provide some clarity to this common challenge. If one party has been clear that it only wishes to be bound by a formal signed contract, the court is less likely to infer acceptance of the contract at any earlier stage. The more complex the subject matter of the contract, the courts are less likely to believe that the parties intended to be bound before a written contract had been produced. The provision by one party of a contract with a signature space does not require it to be signed to be binding, but it's a helpful argument to show that the party did not intend to be bound until signature. The Information Commissioner's Office, the ICO, has prosecuted an individual under the Computer Misuse Act of 1990 for unauthorised access to computer material. The individual had been an employee of a car repair business and, after moving to a competitor, accessed his former employer's computer system using an ex-colleague's login details to obtain thousands of records of customer data. The individual has been sentenced to a 6 months imprisonment. Now, this is the first occasion that the ICO has prosecuted under a law which carries a custodial sentence. In addition to the ICO showing its willingness to flex its muscles with criminal prosecutions, it has also recently reported that the average fine for a data breach has doubled in the last year to $146,000, and the total value of penalties rose to $4.98 million, up 24% from $4 million the year before. The recent case of Tenon FM v Corley has demonstrated the importance of ensuring employment contracts are signed and that a good process is followed. Corley's career with Tenon spanned from 2008 to 2018, and she was promoted several times, ultimately to Operations Director. After resigning, Ms Corley worked for a rival company, and Tenon claimed that she was in breach of her restrictive covenants, but was unable to produce a signed copy of the latest contracts that contained the restrictive covenants. Tenon argued that Corley had accepted these by her conduct of working for the company, but the court refused Tenon's claim, stating it's only possible to accept something by conduct that has immediate effect, so that excludes restrictive covenants that are only applicable after termination. The court noted that Tenon had an employment department but still had not managed to follow the good process of ensuring there was a signed contract. It seems therefore that companies with a HR department will be expected to operate to a higher standard. In addition, the court noted that Tenon had not been able to show that Cawley had received any payment for accepting the restrictive covenants. It's therefore important to clearly link new restrictive covenants with something that you are giving to the employee, usually higher pay with a more senior role. The Court of Appeal has decided that co-workers can be liable to an employee who has been dismissed for whistleblowing. In this case, a newly appointed CEO was dismissed after he reported serious wrongdoings of senior staff. He brought an unfair dismissal claim against the company and the non-executive directors who had dismissed him. Now, last year this claim was successful in the Employment Appeal Tribunal, the EAT, and the Court of Appeal has now upheld the EAT decision. The company being insolvent left the non-executive directors personally liable for the $1.8 million claim. Now, this case is likely to increase the trend of individual employees being named as respondents. Following the Court of Appeal's recent decision to stop the Telegraph from publishing allegations of discreditable conduct that were protected by non-disclosure agreements, NDAs, Theresa May has said that the government would review the potentially unethical use of NDAs. It's likely that clearer guidance or regulation will follow. Now, on a similar point, the Solicitors Regulation Authority issued a warning notice earlier this year stating that solicitors should not use NDAs in circumstances where the subject may, as a result of the use of the NDA, feel unable to notify the SRA or other regulators or law enforcement agencies of conduct which might otherwise be reportable. ACAS has published new advice providing top tips for employers on how to treat their staff fairly. The new advice comes as research revealed only 1 in 4 organisations have adapted their performance management processes to accommodate staff with special needs, disabilities and conditions such as dyslexia and autism. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please contact me or any of my colleagues at Radius Law. We'll be back in January with our special edition where we will review the legal changes anticipated in 2019.